This is the Westminster Standard Podcast. I'm Ryan Beasy. Welcome. Today we are joined by a panel of all-stars. Ruling Elder Jim Eggert, welcome. First time on the program.
Thank you. It's good to be here.
Since you're a first-timer, would you introduce yourself, and then we'll talk about the other men.
My name is Jim Eggert. I'm a ruling elder in Southwest Florida Presbytery, Westminster Presbyterian Church. What else do you want to know about me? Anything?
Anything? You've got a family, I presume, and
yes.
How long have you been a ruling elder?
3 adult sons. I became a ruling elder, I think it was in maybe around 1995 or so. It's been a long time. I've served as the clerk of my session, serving on the SJC right now, actually coming up to the end of a term. See if I'll be elected again. I don't know.
You may not be after coming on this program.
Anything's possible. But love the church, love the PCA, came into it really as an adult, growing up as a charismatic Methodist, strangely enough, more charismatic than Methodist, and found the PCA in adulthood, early adulthood, and grown in Christ since then. So thankful for my PCA church, where I've been my entire church life as a PCA person. I served there. It's really God's grace.
Wonderful. And as you mentioned, you are on the SJC, so I presume that nothing you say here will relate to any pending or impending case. Is that correct?
Not only do you presume that, it is the case.
It is the case. That's no one should presume, but I'm glad that is the case. And then Matt Lee, you're a ruling elder in Northwest Georgia Presbytery. You've been on a number of times. I've lost count. I might have to take my shoes off to count the number of times. And then Jason Piland, you're a teaching elder planting a church near Hudson, Ohio, if you can believe Ohio exists.
That's exactly right. Yes, we began worshiping in January at a nearby community called Peninsula. And no, it is not actually a peninsula, but in Peninsula, Ohio. We're excited about the work that the Lord's doing at Western Reserve Presbyterian Church. So it's been an exciting road so far these first 6 months.
It's a very significant bike path, as I recall, in Peninsula.
That's exactly
Ohio.
right. That's exactly right.
Yes, keeps the bikers off the road. And Joseph Pipa, you are one of the PCA founding fathers and a member of Calvary Presbytery, president emeritus of Greenville Seminary, and I think they named a hall after you, didn't they?
Yeah, they did. That was very nice.
And Tim Rice, you're in law enforcement, ruling elder, military veteran, serving at Oconee Presbyterian Church, and keeping the nuclear power plant safe, as I remember.
Somebody's got to do it.
Yes, and we're very appreciative of that. This year we have 91 overtures to consider, one left over from last year, and then 90 that are new this year. That's a lot of overtures. And so, Dr. Pipa, as one of the PCA founding fathers, I was wondering if you could, if we've got some bandwidth left, just assess the health of the PCA over her years. Do you think many overtures are good? Do you think that that those founders would have been shocked at the number of overtures, or what's your perspective as a founding father?
All right, there we go. I've always considered it to be unfortunate that we have a loose leaf binder book of church order. It's way too easy and cumbersome to devote our time to this. We've become such a political church. I would love an overture that would put a moratorium on any overtures for any book of church overtures for another 5 or 6, 7 years. We can fine tune all day long. I recognize that one of the things we try to do is get the book of order more responsive to problems that have crept up now that we didn't have when we started. But I think we could address those problems probably in other ways. No, I don't like it. I think that we had a good commentary on it in Dr. Smith, who basically had been trained to do this stuff. The conservatives in the PCOS sent Dr. Smith and Al Freund to the PCOS General Assembly every year so they could learn how to run a church. And God's providence, Mr. Freund did not go with us, but Dr. Smith was well prepared to become the first stated clerk, but also to craft particularly the governmental part. You can tell from the rules of discipline that was put together by lawyers, and it is definitely, I think, way too technical, not pastoral enough. And then the directory of worship, of course, is a joke. We're the only Presbyterian church in the history of Presbyterianism not to have a constitutional book of church order. And as I remember correctly, that was never the design. It was merely a matter of time. And that then we get back and get that done. And others took advantage then of that not having been nailed down initially. So the overtures that are attempting to get at leadership, I think, are important, because I don't know if they do, but you talk about grassroots, Ryan. As the church has evolved, power has become concentrated in those coordinators to such a degree. I witnessed it even early on in the denomination. I was chairman of the C committee for 4 or 5 years, and every year I was locking heads with a man who once was a good friend, who was the coordinator. And then when the RPCS came in, they put their man on those committees as well as kind of a vice coordinator. They were much more committed to centralized power. And so we steadily lost the grassroots. I don't want to take too much time on this. We've got the committee of commissioners was a novel idea, and it worked because it kept the committees accountable to the assembly. And it got to the point where those were just rubber stamp things, where the committee could write its report and they passed the report, look at the minutes, but they were doing things on their own and they were not getting new programs. So it's been good in the last few assemblies that we've called about 3 of the committees to an accounting. But that, I think, one is still ignoring what they were told to do. So until we're not going to really get power back where it belongs until we get coordinators who see themselves as servants of the church. Now, it's encouraging that we will have a new clerk and that we will have a new coordinator for M&A. So it's quite possible then that, because what's happening at the church level is very encouraging. But I'll stop there. I just think there's way too many overtures. I don't think that's what grassroots is all about. But
and that's helpful perspective, Jim. You're new to the podcast scene, but you're not new to the courts of the church. Have these overtures that refine our polity and our procedure, have they been helpful to the Judicial Commission, or is it a mixed bag?
Yeah, it's a great question. I think I would say, and you're talking about overtures over past years relating to rules of discipline and so forth. I think as an SJC member, I don't know that I have a particularly strong position about those changes. I accept the will of the assembly is kind of my point of view about that. If the wisdom of the assembly is to change something in our rules, I will apply it. And if they're good changes, I'm in favor of them. If they're not good changes, I tend to oppose them. But whether I like them or not, they're mine to obey as a SJC member.
That's what we need in our judges, right? Well, speaking of changes, I want to consider some of the proposed changes that we have before us. And the first one we'll consider, I think, ruling out of Jim Eggert, you are the author that trying to refine our procedure that we adopted a year or two ago that said that anyone can be represented at any level of the church courts by anyone. And I think your overture tries to refine that you have to be an officer to represent at the broader levels of the church court. You want to help us out here in understanding this overture? 56 from Southwest Florida. I
will try to help you out. And I say this with caution that I'm also a lawyer. So here I've thrown into all of these overtures. I'm like a double offender. here. I'm but, this overture is it's meant as a refinement of our existing change. I think the concern generally was that people have adequate representation, which is important in the church courts. If they feel they need representation, that they be represented. My concept in proposing this overture is to allow only those who operate in the courts as representatives to be people who are vetted to be members of the courts of the church, namely officers, with one exception at the church level, at the local church level. It's understandable at the local church level that if someone's being prosecuted for an indictment, that they may not feel comfortable with their elder or one of their elders or officers representing them, because it's not uncommon in that scenario that it's the elders that are the ones bringing the case. And so they might not feel they're going to get the assistance that they feel they need out of their own elders. And so our old rules and my proposed current rule will allow someone from their own church, if they would like that, or they can use any other officer from anywhere else inside of their presbytery, essentially. The notion of officer-driven participation of representatives is built on the idea that those who serve in the courts of the church should be officers of the courts of the church. That's my principle. And also the principle that officers of the church are sufficient to the operation of the necessities of any judicial proceedings, because by God's grace, God has assigned all of the needs of the church to be ruled by its officers. And so representatives are acting solely in a representative capacity inside the courts of the church. They should be people who know the rules, not only know the rules and been trained in them, but they should be people, godly men who are vetted. They've been vetted as officers, so they have passed all of those standards of qualification. You think of some of those important qualifications, such as being sober-minded, self-controlled, respectable, not quarrelsome, and also who understand the ends of discipline. Going on to what the previous comment was, is understanding the ends of discipline is really important to actually doing the process well, because a good representative is going to help the person that he is assisting, even if they are a violator of some sort, to come to the right resolution of the case. And so I'm proposing that we refine it. It's possible that we're going to have people. Lawyers tend to be attracted to this sort of business, and they might, when lawyers show up and they remember a good standing of a PCA church and so forth, they're wonderful people, but they might tend to bring the practices of the civil courts into the ecclesiastical courts, which are not the same thing at all. They don't have the same ends or purposes exactly. And so we can sort of anticipate that we might make our courts a little more litigious if we allow anyone of the choice of a defendant to have someone represent them before the courts. Imagine if you're in a session and then some lawyer walks in as you try to conduct this trial, and you might imagine how that could go. And that's my proposal and the reason for it.
And I think that's good reasoning, especially that our doctrine of ordination requires us to believe that Christ has given his church everything she needs by means of her officers. Now, Jason, you're also a lawyer, or you're a recovering lawyer like Fred Greco, our stated clerk-elect or nominee, I suppose. How do you read this potential change? And you're a member of the CCB?
That's correct.
Committee?
That's correct. Yes, I am. I'm on that committee, and am honored to serve as its chair currently. And yeah, I had a season of practicing law prior to pursuing ministry, and so these things, I don't often share that, but I think people know by now. But because I don't want those cards stacked against me when I come to argue these things, but I know I really appreciate that explanation that Jim gave for this. I think primarily what stood out to me was ensuring the character of these people who are standing before the court and arguing a case before the court, and ensuring that based on people being ordained and meeting those qualifications. I think that's helpful. I mean, my general disposition in these kinds of situations is I want the broadest access to the best kind of representation, and so I struggle wanting to limit representation because I want an individual at a church who feels like their session's railroading them, whether they are or aren't. I want them to be confident in the people that they can find to help them with their case. And so I generally want to have as broad of an avenue for them to find help as possible. because I think that leads to greater trust in the system. But I do think in this particular case, there's a lot of reasonable pieces that Jim brings to the table with this proposal, that Southwest Florida Presbytery brings to the table, to the General Assembly. And so I'm kind of still sitting on the fence on this one, although I think the character argument may put me over the edge to say, yeah, we do want people of character standing before the court and making arguments that are honest. And so I think there's a lot to commend about this proposal.
Mm. And Tim, I'm sure in your time in law enforcement, you've seen how helpful or harmful good counsel can be to an accused person. If the person has good counsel, the case is going to go very differently. That there a much greater chance of justice. What do you think, Tim? Would this prohibit a non-officer as assistant counsel?
From the sound of it, I would say no, but we have the author here. As the lead meets qualifications, it sounds like anyone else could be like an assistant, which would add to that support and that credence of process that Mr. Piland was talking about.
Yeah, and I think it probably depends on what we mean by an assistant. I think a court or an individual could have multiple people representing them, and I know there's questions and presbyteries differ on this, and Jim can speak to this better than I can. If he's somebody that's speaking for the accused, then I think they would have to comply with this provision. If there's somebody kind of in the back room helping them, think through arguments and helping them draft things, I don't think they would have to comply with this. So anybody could do that. But if they're speaking in court on behalf of an accused, then they must comply with this provision in 3219.
Yeah, the idea here is it's a representative, and to me that's the focal point of this, and has traditionally been of this entire section, is that someone who is a representative. In other words, they're standing in for the person who is involved in the case, the party to the case. They're representing the party of the case, and so there's a kind of agency there on their behalf. And it's true, many people assist. If you think about it in the broadest terms, many people might assist in any given case. If you had someone indicted, they might get assistance from lots of people, beginning with maybe their spouse and their friends and their, the idea of assistance is a very broad idea. What do you think I should do? How should I handle this case? How should I handle this witness? What should I do with this kind of evidence? There are many people you might ask assistance from, and there's no, I don't think, general prescription regarding assistance in the BCO, and thankfully so. You're going to get a lot of assistance.
Yes,
but representation is different.
Right. And I think even in the English, there's a difference between a solicitor and a barrister in English law, and so the counselor is going to be the one who's before the court, but you can have dozens and dozens of assistants and advisors, I think, as that last sentence says. But it's so important that a man or woman receive adequate counsel at the higher court. And who's better to know our rules of discipline than an elder?
Hopefully.
Well, one would hope. Any other thoughts on this Overture 56? All right, well, let's move on then to Overture 16, clarifying circularizing the court. Matt Lee, as the nursery coordinator of Christ Covenant there in Woodstock, do you have any idea what it means to circularize a court?
I will ask my nursery kiddos next week if they have any input on this one. But yeah, thank you once again for having the nursery volunteers of the BCA represented on your lovely podcast here.
We're all about representation.
Yes, thank you. I think circularizing refers to working around the judicial process by talking to people, to folks who may be able to weigh in on the decision in the judicial process. And so instead of going through the courts in the way that our BCO and our Book of Disciplines prescribes, circularizing would be kind of circumventing the normal process by gathering votes on your side, perhaps, or figuring out where people might stand. So I think, as I understand it, this overture seeks to clarify that where the circularizing is taking place is in the higher court. And I think in that sense, this is a helpful revision to our book.
And I wonder, has the fact that the court was allegedly circularized ever played into a significant factor in a judicial case? Do you remember anything coming before the SJC where one party said this was people were circularizing the court, and it was actually significant at the original jurisdiction level?
Yes. If you look at your handbook, you'll see Bulkley v. Highlands is being reported out. It's your commissioner's handbook at 2211, page 2211 this year. And you will find there my concurring opinion relating to this issue. This issue became a very important issue to the parties at the lower court. They believed that circularization had occurred, and they wanted some type of remedy related to the circularization. And that's the genesis of the writing of this, is really the Bulkley case. And you can see my concurrence there, which kind of lays out in much more detail than you'll see even in the overture, the reasons why this proposal has arisen from my presbytery. The general idea, it used to be when the PCA began in the old PCUS that you could only file a complaint with the next higher court. There was no such thing as filing your complaint with the court of original jurisdiction, which in a way was kind of an elegant procedural way to handle the problem. But then it was changed to say, well, why don't we let the court fix itself first, which is not a terrible idea either. And so that change was made in 1984. And along with that, that's when circularization emerged for the first time in the history of the book, or a prohibition on circularization. But it seems that that became a point of confusion later on, because when the court of original jurisdiction is taking up a complaint, in effect, it's like a motion to reconsider. In effect, it's essentially the same thing. Why shouldn't the court be able to talk to itself about whether it wants to change its mind openly and freely without any restriction? Because in truth, the idea of circularization is that the parties aren't supposed to circularize a court. But who's the party at the court of original jurisdiction when a complaint has been filed? Who is the party? Who are the parties? Well, you'd have to have adverse persons in order to figure out who the parties are. But we don't know that the court is adverse to changing its mind yet. So the court might be saying, yeah, I agree, our Eggert decision was wrong. We should change our mind. And so we don't know that there is an adverse party to the proposal. And so I think we should allow just a free reign of conversation, just like we do every other issue at presbytery or session level, to try to resolve a question amicably with God's grace and the Spirit of God working among us, rather than formalize the thing until we go to the higher courts. Then we should prevent circularization. That's the notion of this overture.
I remember when I was trying to make a complaint against something that my previous presbytery had done, I was concerned that if I tried to recruit other people to the complaint, that someone would accuse me of circularizing the court. And so I talked about it with the two elders who rode up to presbytery with me in the car. And if anybody else wanted to join our complaint, I said, no, I don't want to be accused of circularizing the court, because there's such confusion about what it actually is. I think this would be a helpful clarification that it doesn't refer to the court of original jurisdiction. It's only in the broader court, which, the SJC manual clearly prohibits. And then this is simply applying that principle, it seems, to the presbytery in those sorts of situations on review.
There's no prohibition on parallelogramming the court. So,
yes. Any other thoughts on Overture 16? All right. Well, we'll move on to Overture 35 from Ileana. I like this one in theory. It requires that an indictment actually be issued within 60 days promptly. And then the penalty for a failure to issue an indictment is you appoint a new prosecutor, and then he has, I take it, 60 days. And if he doesn't, all that to say, I don't know what this would actually change other than the prosecutor.
That's right. I don't think that this has really any real teeth. And so I think CCB points out there's a little bit of ambiguity here when it speaks of within 60 days following the meeting of the court. And you say you presume the 60 days applies to the next prosecutor. It doesn't say that explicitly. Maybe that's the intent, but it doesn't say that. What meeting of the court is this speaking of with the 60-day timeline? I agree. I mean, I'm would generally be a fan of a Speedy Trial Act kind of a deal, but I don't know that this actually it doesn't have teeth to enforce anything, and I think there's probably a better way to go about requiring some more quickly moving prosecution than this.
Of course, justice delayed is justice denied for either party. What happens when a man is, been found to have a strong presumption of guilt, but he doesn't have an indictment for months, and eventually, because a trial is a benefit to the accused, is it not? To have the presbytery say we presume he's guilty, but then wait for months, a year to issue an indictment is a grievous offense to justice. Dr. Pipa, in your time in the PCA, do you have much experience with indictments and how long they usually take to be issued?
No, I don't.
That's good.
The two times I know that I had to do a case in the old Texas Presbytery, and we moved with great dispatch. So I was in San Antonio investigating, got the indictment to the court. So again, I'm sure that Mr. Eggert would have a better idea of the people have used delaying tactics and such as that. But that was not been my limited experience has not been that way.
Well, Jim, have you seen on the SJC situations where there's an indictment not issued for a long time, and it seems like an unreasonable delay? Obviously, sometimes it takes a while to get the witnesses collected and collate the files, but is there anything that you'd be comfortable commenting on?
Yeah, I can't comment on any pending cases, but
of course,
I don't remember reading a case before I came on the SJC, or a case since I've come on the SJC, unless memory is failing me, where we did have a problem specifically of that nature, of a slow walking prosecutor, a slow walking indictment. My general thought on this overture is that I'm certainly open to the sentiment that the swiftness to it is really in the interest of Christ. In the rules of discipline, the purposes of discipline would seem to, in general, require swiftness. But again, I hate to be too universal about all these sorts of things. I'm more inclined to allow courts to move matters at a pace that is appropriate to the facts and circumstances of the case. And it might be that there are cases where an accused might wish it was swifter, but in truth, it might need to be a little bit slower. And there may be disagreement about how swift it should be. And then you start imposing things like, 60 days or 90 days. And then, what's the remedy? Well, we dismissed the case against him, with prejudice? So now there's a scandalizing the whole church, and now there's nothing we can do about it because the presbytery, was incompetent in the way that it handled its procedure. That doesn't seem like a great solution either. So I don't have great solutions. I pray for the grace and mercy of Christ that he would bring to the courts, that we could do our job faithfully, and that we entrust to these godly men to do what needs to be done, and not do what doesn't need to be done, frankly. So that's my general perspective. I'm open to the sentiment of this overture, but I'm not sure that it very clearly sets a path, or that there is a very good path to solve the proposed problem of a delayed indictment.
Right. And from what I've heard, the Irish Air Force may be coming to the rescue on this one with some amendments at overtures. Matt.
A clarifying question. So if, Jim, in your advice on this, you suggest that some cases need a little bit more slowness because the process for collecting evidence or information might take more time, and so maybe 60 days is not enough time to prepare an indictment. But if that's the case, and if some evidence is still forthcoming, or if the investigation is still in process, couldn't the court simply meet again to say, "Hey, there's new evidence. We now have a more complete picture of what's going on," and then the 60-day clock just restarts at that new moment?
it's a fair point, but I suppose it's not a point that will be of much comfort to the accused, who just feels that he's being continually, every 60 days, they're going to come back at the next Presbyterian meeting and restart the clock because now there's something else against me.
Well,
that's what I fear.
Jim, help me out here. To do the indictment, you don't have to have all your ducks in order, do you, in terms of arranging your witnesses and you're going to do the indictment. That's not putting a time limit on further gathering of evidence, is it? Or does it?
I would be deferential to how a presbytery was going to do a particular case, but I mean, I think that the rules say that you're supposed to specify or give specificity in the indictment, and you're supposed to identify witnesses.
That's true. Yeah, that's true.
So, and the notion of that is that you want to put the accused on fair notice of what his trial is going to be about.
Right.
He has a fair process, and he can defend himself adequately, and that's usually where the disputes can arise as to whether he's been given a fair view of what the trial is about, or not.
Yes, if possible.
60 days could also hurt the defendant then.
Yeah, I mean, if you keep pushing it off, right, or you get the indictment wrong.
Yeah, he might want more time himself to.
Right.
Yeah.
It's why my tendency is to defer to presbyteries with all our imperfections. I don't have a greater solution, but to trust that godly men acting collectively together as the courts of the church will do the right thing. And we know that there are errors that are made by courts from time to time, but I don't know that I've got a great solution for this kind of scenario, because what we're talking about is clearly an error, right? If it's delayed, then the only thing this would try to regulate is when it was wrong, that where the indictment should have been brought sooner, not when it should have been, there should have been more time in the nature of the case.
Right.
And I think you highlighted an important issue, that our courts are supposed to be made up of godly men acting with integrity, and perhaps the genesis of such an overture is a concern that if there is a situation where an indictment was delayed for a great deal of time, that may not, that we need something in writing to compel the charges are reduced to writing rather than just a broad what we presume.
But this is Presbyterianism. There's nothing that happens fast in Presbyterianism.
Amen. And that's a feature, not a bug.
Well, and
perhaps some sort of Presbyterian Bill of Rights specifying that folks have the right to a speedy trial. If that's the case, then it seems like maybe a revision to our preliminary principles is a better strategy for attacking this potential problem than an actual change to our procedure. Right.
Potential problem is a good phrase to focus on, because the potential problem is based on the idea that there is an epidemic kind of problem among the courts of the church that needs to be regulated. And I think that's kind of a core question here as to whether or not, because you don't want to create a rule that is truly an exceptional situation, in my view. Courts can err. Even godly men acting together in holiness can err, and do something wrong. It happens. Courts can err, but they don't always err, and they don't usually err. Or we don't assume that they're usually going to err either.
Yes. Well, any other comments on Overture 35, requiring an indictment to be issued within 60 days? All right. Well, let's move on to number 46. This one would prohibit potential discussion of possible unconstitutional actions until a court has received word of it. Tim, you and I have been on podcasts together, and we've talked about, and we've asked questions about the constitutionality of various things. I wonder, Tim, do you think this is the worst overture of GA 26 or 53, 2026?
Well, I think it's pretty close. If someone believes that something that has been said, whether it be online or somewhere on social media, is an issue or is a problem, then there's a court remedy for that already. I don't think we need to add clarification that it might be or probable violation. If there's something that you believe is a violation, then use the courts to address that violation, as opposed to amending the BCO to create something that's maybe at all, seems to me anyway, to be able to address that thing. So it seems like a way around using the court in the correct way and just adding a lower threshold to be able to use the court to me.
Well, it seems to be a way around as well, and this seems to have grown out of the public video that was released when one of our high-ranking officers took part in a man renouncing the church and going into papacy. And some people were offended that was released in that manner, but it was a public audio, video that was released, and people did interact with that. Or the same thing a year ago with the stated clerk, when there's public information there, people become aware of it without it being a violation of the commandment if you just put out the facts. And I think this is probably because there was a pretty strong minority reaction to both of those things, that they've not been dealt with in a proper manner. But you're not violating the ninth commandment if you release a video or whatever that records these things. And so, I think it's an attempt to make everything even more difficult to get to in terms of when there's been public violations of integrity or the Constitution.
Yeah, and that's an important word that you use there, is public, right? If I sin against someone privately and I'm not ordained, right? Because I think there's an argument to be made that any sin committed by an officer is in a sense a public sin. But if I'm not ordained and I sin against someone privately, that person has a duty to come to me privately first. But if I sin in a public way, there's no obligation. Matthew 18 is not dealing with public sins by public persons, if I understand the book correctly. And I won't tell you which book I'm referring to.
I agree with you, though.
I think there are problems, I think, with the way people utilize social media to discuss matters of importance to the church. And I do think there are concerns there. However, this is not the way to go about that. The way to go about that is just courts to address the issues internally and to bring their own members to account for their actual sins, not creating this new category of a what do they call it? A probable sin. That's not helpful. How does this work with 31.2 investigations and a strong presumption of guilt? We're creating a new category, not clarifying how they work together. And to say, if you make a public statement that somebody else is wrong, that's probably wrong. That's probably sin. That just kind of blows me away. And I think there's a lot of problems here. And as CCB report notes, Jesus often would call people out publicly without going to the Sanhedrin first to call them to account. And so I think there's biblical warrant for sometimes doing that. It's necessary. Not always, but there are times where it is necessary.
Well, I'm just noting as a lawyer, just looking at the drafting of it, I'm just intrigued by the drafting of it. It says any public statement made outside of a court. So I'm struck by its universality. The proposal, this would apply to people not in the church, at least in theory. Any public statement, anything that anybody puts on Twitter or elsewhere or makes publicly. So it's probably not what's intended, but it seems like that's a very broad statement that is being alluded to there. And it's also interesting, just as a note, as a drafter, as a lawyer from the lawyer's perspective, sorry for being the lawyer, any public statement made outside of a court of the church. So we're giving immunity to statements inside of the court of the church? Surely that can't be intended, right? But it seems to almost be intended by that, so I think there's a lot of perfection if we're going to do something like this, that this could probably stand to get at what's really intended here, because I don't think this means to give immunity. Well, if you're inside the church, kind of like in Congress, you have absolute immunity in Congress to say anything about anybody. Surely that's not what's intended here. But yeah, it's just tough to try to write overtures about things like this. It really is.
Yeah. Matt, I think you were also trying to say something.
Yeah, just two quick things. To Jason's point, you also have the biblical example of Paul confronting Peter publicly And so another example of how that should be done appropriately. And then to Jim's point, I struggled with the juxtaposition of the wording shall and probable. Shall suggests certainty, and probable very much does not suggest certainty. And so I think there's a lot of problematic wording with this before it could be considered.
Mm. And I think the Ninth Commandment already gives us everything we need. And as the CCB noted, I believe it was CCB noted, this is taking the Ninth Commandment and interpreting it in a way that it has never been understood before, that any public statement about a public issue, I wonder, some of you have perhaps read the M&A report written by the interim coordinator that highlights serious, egregious financial mismanagement to try to that I suppose something like that could be perceived as in violation because it's a public statement now, and it's outside of the court in that it's not been given to the court yet. I also, my heart goes out to abuse victims. Someone who's been allegedly abused and doesn't have the wherewithal to know how to file a 31-2. It seems like that if someone claims to be abused, the only recourse that person would have to figure out how to file a 31-2 if this were adopted.
Well, it says outside of a court of the church. So I think any session meeting, you can say it at any session.
Yeah, no, anybody has access to the church court to bring a charge.
Okay, all right. Well, that makes me feel a little bit better, but I'm still against it.
Well, this would be our example. Take your example, and what this would prohibit is that person shouldn't do this. But again, as you men have said, we have ways of dealing with that. What's happening lately, for a number of years now, is victims from the past, rather than going to the appropriate church court, have gone online and suddenly exposed things that supposedly happened 20 years ago. And then that's, forced all kinds of things in the church court where they should have gone to the church court 20 years ago or whenever they became aware that it was a violation. Mm-hmm. But they've actually used it. And that could be what's behind this, because people are using that as well on the woke side of things to discredit conservative people.
Very much so. And then I wonder, if I just saw today, as of this recording, Matthew Everhard did a podcast on, just discussing the M&A coordinator's report. Well, is it legal to do if this were adopted, would it be legal to have a podcast discussing something that's come up in a church court in a public setting? I don't know. As a podcaster myself, I have questions, many questions. Well, any other comments on this, arguably the worst overture of 2026? All right. Well, let's move on to Overture 75 from Central Florida Presbytery. I'm struggling to think of a superlative for this one, so I won't venture. But it purports to give some clarity on what is notice of appeal. It must be written. But I wonder, was the book intentionally vague on what notice of appeal is?
I think this is absolutely, rewriting what our book says, because notice of appeal clearly is distinguished from written notice of appeal in the book and the way it's written now. And what that does, that protects the accused, the one who intends to go to the higher court to ask for review of their trial. And you can provide notice of appeal orally. You can provide a slip of paper, that says, hey, I'm intending to appeal. But that's different from your written notice of appeal with reasons. And that's required to be filed within 30 days. But that's different from simply providing notice, hey, I'm going to appeal it. And the importance is when you provide notice, at that moment, the censure is stayed unless the censure is not executed any longer until or unless the court by a higher threshold requires the censure to stay in place during the pendency of the appeal. And so what this does is then it will require that the accused is under censure until he can, write up his full appeal with all of his reasons. And usually you're going to take all 30 days to do that. You want to make sure you're highlighting every piece of error. You want to get a copy of the transcript so that you can go back through every piece and allege every error that you can to get that before the higher court. And so what this is doing is this is requiring that somebody who has been found guilty, they no longer have that avenue of providing initial notice and that censure being stayed until the higher court reviews it. And this requires that censure to continue, even if they have a very strong case to go before the higher court. That will continue till at least they file their appeal in writing with reasons, and that will take 30 days. So, I mean, this is rewriting what we have, which is fine. We propose rewritings all the time, but I don't think this is consistent with the way the book is currently written and should be read. And they're wanting to change that, which is fine. I think we need to protect, again, the accused. Even when they're found guilty, they have the right to go to a higher court. And this notice of appeal clearly includes a verbal notice provided in the presence of the court. And so that would then begin that process. So I think this is unnecessary and encumbers our system far more than it should.
Would you say it's unnecessary, unhelpful, and unloving?
I agree. Yes, I would say that.
And as a former clerk of Presbytery, possibly in the lower 50th percentile of Presbytery clerks myself, we thank mercifully we had no one appeal anything during my short tenure as a clerk. But I would have appreciated notice that day so that I know I need to preserve all of everything.
Yeah.
I would
begin getting the transcript put together. Yeah,
that takes time.
Yep.
I would hate for someone on day 28 to have submitted this written notice with his 6 supporting reasons or citing all 6 of the grounds for appeal or such as, and then I realize, I need to now start getting everything ready. This just seems, unnecessary, unloving, and unhelpful as some overtures are. Any other thoughts on this, perhaps the most unhelpful overture of 2026? All right. Well, we'll move on to objections. Matt, I think this is from your presbytery.
Yeah,
Do you want to defend your presbytery?
I would be happy to defend my presbytery. Yeah.
One of the great presbyteries.
It is the best in my opinion. But
what number?
Overture 85.
This is 85 regarding objections, inserting a whole chapter. This 44 used to be my favorite chapter in the entire book. Now, I don't know.
Yeah, the Polity Matters guys would have to record an entire episode instead of leaving their silent 2 minutes or whatever it was up on their podcast. So I don't think it actually spills more ink, though. The contents of what would now become Chapter 44 are already part of Chapter 45. And I think the challenge is that Chapter 45 includes not only objections, but then also dissents and protests together. The motivation for this overture is, we've already heard a few comments about how the PCA has become more political and just the judicial process becoming more burdensome, more encumbered. And I think part of that is that we're seeing more cases filed and more cases appealed. Hopefully this could do something to help alleviate that. There was a By Faith article that ran, I don't remember exactly, I could pull it up though, that showed that in recent years, the SJC has dealt with more cases in the 30s and 40s, very, very common. In fact, this past year, I think, was the most in our church's history when you compare with some of the early years of the PCA, where it was, maybe in the teens of cases in a year. Obviously, Jim, you could speak more to this if you like. I think part of that is because if there is a teaching elder, for example, who is a party to a case at the presbytery level, and he disagrees with the conclusion that was reached, right now, as our BCO currently reads, by grouping the dissents, protests, and objections together, it almost feels like the only course of action that he has is to then appeal the case to the Standing Judicial Commission. By separating out the dissents, protests, and objections, it could provide more clearly an avenue for such a teaching elder who couldn't sit on the case and therefore couldn't dissent or protest to object to the decision that was made as opposed to appeal it. And so I think that this would help to alleviate some of that judicial pipeline coming up to the SJC. The point of this is just clarity. It doesn't actually change anything that we do in terms of our polity or our judicial process. Hopefully it brings enough clarity to, again, as I've said, help alleviate the pipeline of cases coming before the SJC.
In a few recent years, there have been some debate at General Assembly about whether a member of General Assembly can make an objection to an SJC decision, and the answer we've received is no. Would this change that?
I'm sorry, say that again?
Would I be able to object to a decision of SJC if this amendment is adopted? I know a number of times men have wanted to object to SJC decisions, and the answer's been no, you are a member of the commission, so you can't object, or you can't, it's done. There's nothing to be done.
I think I will defer to the lawyers on that one. I'm not sure, Ryan.
I would think, I'll defer to Jason, who's our constitutional scholar, but I would think that would not change. Under the old language, any member who did not have the right to vote on an appeal, let's say it was an appeal that the SJC heard, the only people voting on that appeal are the people on the SJC, and the general commissioners of the General Assembly did not have a right to vote on the appeal. So only someone who had a right to vote can file an objection. And that seems
no, the objections if you didn't have the right to vote.
Right.
That's right.
That's correct. They didn't have the right to vote, and so therefore they can't. Well, who did not have? I see what you're saying.
So it doesn't change the language, though, because the language stays the same, whether it is in chapter 45 or chapter 44. I think on its face, that's why men have tried this several times over the years. On its face, it looks like a member of the GA can file an objection to an SJC case. However, it's been ruled by our moderator, I think at least two different moderators, that because all matters related to discipline have been committed by the Assembly to a commission, we don't have the right then to kind of go back to the commission's work and as a body object to that. We've given our right to object over to the commission itself. And so that's generally been the holding. I don't think the language changes that. I don't love that. I think practically it makes sense. We don't want every case people to line up at tables and sign their names to object to cases. I get that. But I think the language of it to me looks more like, yeah, members of General Assembly should be able to object to cases. And that doesn't change. I just disagree with the moderators that have ruled that way, that you cannot.
Ryan, I do have kind of a question for this overture, and I guess it's author or source. One of the old versions said that any member who didn't have a right to vote can file the objection. The new language says any teaching elder or commissioned ruling elder. And so down at the lower level of actions of presbytery, I've always wondered whether a session could file an objection as a court of the church, and whether that language might inhibit a session from acting collectively, or if it can only act through a commissioned elder there. And that was just kind of a point of curiosity or interest, because it seems like we probably want to preserve the right of a session to object to an act that they couldn't vote on as well, or they thought something was objectionable that the presbytery had done, because the churches are members of the presbytery, and maybe their commissioned ruling elder wasn't opposed to it, but maybe the session as a whole was.
Yeah, that's a great point, Jim. I hadn't thought of that. I think the idea was more that if the General Assembly does something, then does this open up for any ruling elder throughout the PCA to then file an objection based on the discussion of how previous moderators have ruled? Perhaps not. And I think you're right. I think it would be important to preserve the right of a session to object to something, even if the specific commission ruling elder did not. So perhaps that was the reason for that small wording amendment. Perhaps it needs to be amended again to the original language by the Overtures Committee before it can be considered.
Well, and I wonder if that would then open it up to make it more clear that any teaching elder, rather than any member of the court.
That's right.
Because SJC is the court of the GA for judicial matters. I don't know.
And it looks to me in the old 45-1, the first paragraph says any member of a court who had a right to vote, and it talks about dissent or protest. Third paragraph, any member who did not have the right. So I think they've elided that language of a court. I think it's implying any member of a court who did not have a right to vote. So I think that language, as the question points out, I do think that may be superior than saying any teaching elder or commissioned ruling elder. So overtures could consider that and say any member of a court who did not have the right. I think that may be helpful, Mehmet.
Yeah, and I think if that's the case, then if 44.1 is appealing to language that actually follows based on how this has been reordered,
Right.
maybe reordering the chapters again so that chapter 44 then becomes about dissents and protests, and then chapter 45 becomes about objections, could be a helpful reordering as well.
Well, that's all that I had on the docket for overtures related to judicial procedure. If we could move on to a couple related to agency accountability, unless there's some other overture that anyone wanted to consider in that bucket. All right. Well, let's consider this one from the mythical place of Ohio. Require assessment data from MNA. This laments, I think, something that Dr. Pipa was talking about earlier, the lack of information, the lack of real oversight given by the committees of commissioners. But it also, I think, will help the General Assembly know exactly what's going on in one of our permanent committees, and how many churches are being planted, how many churches are being dissolved, how many people are going through a church planter assessment. We keep hearing these lofty goals of 3,000 churches by 2023 or 2033. We've been about halfway there for about 15 years, so I'm not sure if we're going to close that gap over the next 6 or 7 years. But Jason, I think you're responsible for this. Do you want to do a better job of explaining it?
Well, sure. I'm not responsible for this. It came through my presbytery, through our missions committee, and I didn't draft this.
It has your name on it, buddy.
Well, I attested. Yes, that's right. That our presbytery passed it. That is correct, as the clerk of presbytery. But no, I worked with our committee on kind of their problems, and I think it may be one of those things that looks like it's gunning for somebody, or has trying to take something. It has an offensive angle to this, and my understanding, based on what the committee's been doing and has asking for this information, is it's not a gotcha. It's not trying to be offensive or offensive in that way. What's happened is our church planning committee, our missions committee of our presbytery, has been wanting to work with M&A to provide resources for church plants in the Ohio Presbytery. The chairman, who was working with a number of staff members at M&A, was trying to assess, okay, do we need to require church planting assessment for our planters? So tell us what you guys do. Tell us kind of the results. Yeah, thank you for highlighting my name there. Tell us the results. How does it pan out? What are the results from men going through assessment? And so we want to utilize it if it's something that we can see has a good track record. But we think we can do a lot here on our home front as well. And if you can help us do that here, do some kind of training or assessment locally, we want to do that as well. And so our committee wasn't able to get the data that it felt was necessary to assess whether sending men to assessment would be helpful and best for our presbytery to know how to recruit and train our planters. And so they sent this up to our presbytery. Our presbytery agreed that it would be helpful to have this information. And I think one comment I've gotten from some folks is that it looks like we're requesting particular data on particular planters. And that was not the intent. I don't think the language reads that, but I see why some people might look at it. And on first glance, it looks like we're looking for who you assessed, what their rating was, and how their church plan is doing. It's looking for anonymized data. It's looking for aggregate data of how many people got your rate, the highest rating, and of those, how many are still doing well 5 years out. So it's looking for that kind of data to see, okay, is this effective? How can we utilize the resources we have as a denomination? And how can we improve what we're doing? I think looking at data is important. So that's really all it's trying to do, is to disclose to the assembly, here's our assessment, here's how it's doing. And we want to see this is a great blessing to the church. And so let's put that on the front page of By Faith, and let's do that. So that's the hope and the goal here, is to be able to see how well we're doing with planting and assessing.
Yeah, Jason, when I read it, as someone who works with data in my civil vocation, I thought it was clear that you're talking about anonymized directory level data here. You're talking about data points in the aggregate, and so there's not a privacy concern here. As far as working with data is concerned, this is considered directory level data, there would be no problem with publishing or making this kind of thing available so that people can actually see what the data is and how it's being used. I do, as someone who works with data and with these types of assessments, I think that psychometric assessments have a lot of predictive validity for a lot of later life success. And we see a lot of at least natural evidence of that in industrial organizational psychology in particular. So I don't think this kind of request should be taken in, as Jason said, kind of an offensive way that we're trying to do something with the data to deconstruct something that's going on. No, this is an inquiry into providing some more information so that we can see how it's being used and try to make more helpful use of it. I think a question that I would have is there any evidence right now that these assessments have promoted ministerial effectiveness or longevity? We simply don't know the answers to those questions. And I think providing at least this directory level data is a helpful first step for us to get a much better sense of what is going on with assessment through M&A and just the health of our church planting in general. I would also add that there seems to be a little bit, at least as I read the M&A report, a little bit of discrepancy in M&A's guidance. So at the early part of the report, they mentioned that there was a change to their strategic objective and enabling strategies. And they said that M&A will no longer do anything that is not, and I'll quote exactly here, rooted in an explicit decision or mandate of the General Assembly. But then later on, their advice on this overture in particular was that it should be answered in the negative. Again, I'll quote, with the understanding that M&A will provide requested information in M&A's report. So that seems to be a little bit of an inconsistency to me. Is it consistent for us to expect M&A to do this if they're not given an explicit mandate, given that they've now told us they will only do things when they're given an explicit mandate? I think that this overture does provide that explicit mandate, so I would be in favor of it.
And then if they provide it in 2027, will they continue to provide it going forward if they're not explicitly required to do so by the RAO? One of the things I like about this is it forces actual real accountability. And every year we are treated to dozens and dozens of videos. And every video from our committee or agency is glowingly positive about everything that's happening, as you would expect, right? We don't want a video, we don't want Eeyore producing the videos for our committees and agencies. But we also need data to understand that, yeah, there may be great things going on at this particular church plant and that particular church plant that have been featured in the videos. But, why are we only growing by 7 or 8 churches as a denomination each year? Why are we only growing by a dozen churches? I really don't like it when people get all this, oh, great things are happening. But then when you dig into the data, it's rather unremarkable. Maybe that's just me. I don't like excitement. It's that Germanic side of me. Any other comments on this overture?
Nope.
All right. Well, let's move on to 83, another excellent overture from Northwest Georgia Presbytery. This one deals with requiring ordained men to be teaching Bible and theology at our educational institutions. Tim, you were educated at another one of our sister educational institutions, Erskine, right? You got a THM from Erskine.
That's correct.
Can you provide some context? Are there any non-ordained people teaching Bible and theology at a similar college and seminary? Do you know just offhand?
Off the top of my head, I would say no. All of the persons that taught me were ordained. So don't think that issue is down there for that one.
Were they ordained by NAPARC denomination, though, Tim?
Yes, sir.
Okay, then they've changed on that one. That's good.
Mm-hmm.
Now, again, that might have been just the classes that I was in, but
it just seems obvious to me.
I know, for example, that Philly has tried to have women teaching these courses, because we would have interfaculty discussion when I was at Westminster, California, and we were very opposed to that course of action, and they were pushing for it then. I don't know where they are now, but they've had women teaching Bible courses, I guess.
Yeah, and I think this. So I wasn't the author of this overture, though. Our church did send it up. I think the overture tries to make a distinction between theological courses or systematics versus just kind of Bible courses, and saying that the theological courses and systematic theology, those are the things that need to be taught by ordained men. Our presbytery had a good discussion on this overture as we were considering it. Providentially, we did have a board member of Westminster, California present who said that they already have this policy that all of their theological and systematics professors are ordained men. We had a representative from Birmingham Theological Seminary. He said the same thing. I've spoken to someone from RTS Atlanta just down the road from us. Same thing. Obviously, Dr. Pipa can speak to the policies that Greenville Presbyterian Theological Seminary has. So this just seems kind of commonsensical to me that since Covenant College and Covenant Theological Seminary are institutions of the PCA, that we should also have this kind of policy. Now, I've seen some discussion and some criticism that this seems to be an overture that's a solution in search of a problem. I'm not aware of any problems. There may or may not be, but it just seems to be consistent with our polity and our theology and some of our sister institutions that we have this kind of policy for our higher education institutions, that theological, systematic theology, those types of courses should only be taught by ordained men.
Now, this does go further than what you said a minute ago. It does say systematic study of the Bible or of Bible doctrine. And I would agree with that. I would not want them teaching Bible. And I think this guards against that.
So I'm curious, would I think, we're applying this to our denominational entities, our seminary, our college. Do you think this should apply to local churches that have high schools or things like that? I mean, should it be should there be something to that effect?
I think that would be an overreach by the assembly, because the assembly owns and operates Covenant and Covenant. And then I think there's a distinction to be made. People in a church high school are minors; they're not adults. I think personally the answer is yes, but I think as a grassroots denomination, I would probably vote against any kind of reaching into the school. And
I agree, because we also don't require men teaching at the high school level to be ordained, and that's what you're saying. Right. Yeah, I think that's an overreach.
And I don't personally think churches should operate schools. I think parents should operate schools.
That's right.
But that got me into some interesting conversations when I was in Tennessee Valley. Good, it was nice, but it was just, that's a weird idea.
Right, we already have 91 overtures to discuss without opening up that can of worms. So.
Yes, I take the hint. Any other thoughts on this? What I think is an excellent, commonsensical overture from Northwest Georgia Presbytery. One of the best.
Question for Matt.
Yes.
I noticed that Covenant Theological Seminary, I think, had the committee or board had recommended this overture be answered in the negative with explanation. And I wondered if you just had any comment about.
I did not. I was
take a look at
looking to see if Covenant College had a recommendation, and I
couldn't find it when I looked at Covenant College, but I might have missed it, or maybe they just didn't. The overture came out after they'd already met.
So yeah, the argument is that the seminary is governed by the trustees, or it's governed by the General Assembly via the trustees. And I think my objection would be that doesn't negate the responsibility of the General Assembly to provide oversight on a matter like this anyway. So, yeah, I haven't thought too much about their recommendation here.
And isn't that one of the old debates amongst Presbyterians? Does the board actually function as a board, or is it a board for legal purposes still accountable to the General Assembly, which owns and should operate Covenant and Covenant? The two covenants. We're in a bi-covenantal denomination.
The RPCNA had that problem with Geneva College, which is how it was headed in a very bad direction for a while, because the denomination did not have sufficient control. It was a board made up of some of their people, but of others as well, and it was caused a lot of difficulties. Yeah, our
I think
board does not have that kind of independence from the. I'm sorry that they're defining themselves in that way. It gets back to the grassroots again. Of course, we would never, from the old Southern Church, have wanted to own a college.
I think if that's the biggest objection that Covenant Theological Seminary has, if it would satisfy them to amend this overture to say that the General Assembly directs the trustees to ensure that this is taking place. I don't know, but I think I'd be okay with that kind of direction.
I'm trying to find their grounds.
It says the seminary views this overture as redundant. As the denominational seminary of the PCA, Covenant is wholly governed by the PCA through its trustees, each of whom are duly elected by the GA. An essential component of this relationship is the maintenance of Covenant's theological identity, which is wholly grounded in an unswerving commitment. Am I reading the right thing?
Yeah, that's right. Yeah, I don't see how it's redundant. It's saying that the trustees themselves are ordained officers, but I think the overture is calling for people who teach.
Right.
I just think that either they misread the overture, because this isn't actually addressing ordained elders in NAPART.
And what it goes on to say that, yeah, we require everybody to subscribe to Westminster and teach consistent with the PCA doctrine. So they're saying, I think, they're saying everybody who's teaching is in compliance with our PCA theology, whether or not they're ordained.
They're
seeing it as redundant.
Well, they're avoiding the elephant in the room.
Right.
Yeah, because I know that Covenant College has women teaching in their Bible department. People would complain to me about it as though I had anything to do with it. It's just they were just our neighbors. It's not like I can go up there and say, "You shall not pass." But these grounds, Jim, thank you for bringing up these grounds. I hadn't had a chance to read them yet. They don't seem to actually address the substance that we believe. The authors of this overture are saying we believe that ordained men should be teaching in our denominational schools subjects of Bible and theology. Simply, finding a lady who can subscribe. I mean, my wife could fully subscribe to the Westminster Standards. She may even subscribe with fewer scruples than I do. I don't know. But that doesn't mean that she should be permitted to teach in a denominational school the subject of Bible and theology. That's
well, you should
as
know.
Allison would say. What's that?
You should know if she subscribes.
Curiouser and curiouser. Well, thank you for I'll have to chastise my production team for not having that ready. Those are the overtures related to accountability that I thought we might consider.
There's one more that would be worth talking about, isn't there? And that is 41.
41.
2/3 majority to elect.
Yes, I thought that those would be sort of dealing with procedure.
Okay.
But yeah, let's go there.
Well, it deals with accountability, really. Yeah, you're right.
Yeah, that's true. Yeah. Some of these groupings are just arbitrary. So a 2/3 majority, that could save us some time, maybe. What do we think? Allows for predictability and rhythm. I think there's Overture 40 that has some is related to this, not in the same place, deals with calendar years. So even if you're elected,
that one makes good sense.
Well, what do you think about this one, Dr. Pipa? 2/3 majority.
I like it. I think that perhaps if you join that with maybe a 3-year term, which I hate to, the grassroots was annual election, and yet it's hard to build a program in 1 year or to be very effective. But I think if you join those two things together and got that super majority and a 3-year tenure, that could be useful.
Has any coordinator been elected with less than a 2? I mean, we had some very difficult conversations.
We've had some clerks elected without 2/3, obviously.
Oh, okay, that's right. Just not in my brief tenure.
Yes.
Really?
I don't think Brian Chappell got a 2/3 vote in your brief tenure.
I always thought it was up near the 80s.
Maybe
Less than
so.
80. It was lower than I would have taken a call, but
Yeah.
higher. I always thought it was, higher than 3/4. And I said, well, okay. But so I think
I'm going to advocate for a moment for the status quo in that there is something attractive about 2/3 to make sure there's unanimity, or not unanimous, but a strong
Consensus.
support for our consensus for those who are steering these big organs of our denomination. I like that in theory. I think in practice it will end up we may have more vacancies, and if somebody gets a 60% vote, they're in. But I think they're also realizing I probably shouldn't stay here that long. And I think they could begin that process of winding down their tenure without being forced out. And I think that would probably be a healthier way to transition out, instead of saying, all right, as of now, you no longer can do anything. Instead of let them on their own voluntarily say, hey, it's time for me to move on, alert the committee, get a search process in place. So I would rather that mechanism work for us instead of a hard 2/3 rule. And I do absolutely agree with the fact that you can't do much in a year. Institutionally, a 3-year term makes a lot of sense. So I'm more up in the air on that one, and think that one could be okay. But along with the previous point I made, though, I would rather vote every year as a vote of confidence, and to say if that vote goes down over the course of a couple of years, maybe it's time for the coordinator to realize to say, hey, I may not be the right guy for this role. And so if we are doing it every year, we're getting that annual check-in. How does the General Assembly feel about how they're doing and leading our denomination? And so I'm actually more okay with the status quo, keeping it year by year, keeping it 50%. And the calendar years is okay. My biggest pushback to that, though, is if the Assembly does not reelect somebody, they stay in for 6 more months. And I would rather maybe you amend it to say if somebody's not reelected, they're immediately out, and then the new person doesn't start until January when they're elected. That's fine with me. But that's my concern, is it does leave that loophole open. So there's my apology for it.
I'm quite convinced about the annual voting. That, again, you expressed exactly why we did it that way. But I think you're a bit Pollyanna about when people see their vote down, they leave. They don't do that.
Yeah. We've had some rather low votes that guys just they know that they got 20% of the Assembly against them, and they just stay in until they hold up a Post-it note.
So I'm convinced to stay with the 1 year because of the way you stated it. It is important.
Yeah. And that's the way they do it at Grove City College. You get a 1-year contract. And, Grove City College, some of you may not know this, but that is the finest institution of higher learning to ever award me an undergraduate degree.
Until they went woke for 2 years. And the board had to push the president out. So be careful.
Generally, we have to hold supermajority votes to protect minorities. That's a very common reason to require a 2/3 vote. And I don't know that there's a reason in electing persons to these types of positions for protecting minority rights as such in principle, if that's the principle of a 2/3 vote, usually under parliamentary procedure. Otherwise, we don't do this normally in any kind of election, really, and nor is a man deemed so important, any particular individual so important that it's got to be him, or nobody, because it could be somebody else. So the fact that he doesn't get a supermajority doesn't mean he can't serve, or that he can't be a godly man and serve the Assembly to the best of his ability, or ultimately be removed by the Assembly if the Assembly should so choose by a majority. So yes, I think the status quo has served us for years. I don't see what the reason is or the occasion why we'd want to change the practice.
Yeah, I agree with both Jason and Jim. I think the 2/3 supermajority vote is not some arbitrary thing that, hey, we just want to make the threshold higher for this type of vote. In Robert's rules, it's specifically applied to things that would limit the rights of members of the court, of the Assembly. And like Jim said, when particularly for the minority, to protect the rights of the minority, that's when we have a 2/3 supermajority vote. So things like calling the question, cutting off debate early, that's when we need to apply the 2/3 rule. But applying this threshold to simply for voting for coordinator or for a clerk, I think is not necessary. And I think with respect to the question as to, I've heard a lot of discussion about a year term is simply not long enough for a person to be willing to maybe move to Atlanta or Lawrenceville and to relocate their entire family with that kind of job uncertainty. But I think historically we have not seen that this process has led to intentionally short tenures, at least as far as the stated clerk is concerned. The PCA Historical Center does report on our previous stated clerks, and they've all served relatively long tenures. Morton Smith served for 16 years, Paul Gilchrist for 11 years, Roy Taylor for 22. I think Dr. Chappell, as our most recent stated clerk, was still, 7 or 8 years, relatively short compared to his predecessors, but still much longer than even the 3 or 4 year terms that people are proposing. So again, I do think that is an example of a solution in search of a problem. We haven't had this problem electing our clerks and our coordinators in the past. I don't suspect that it'll continue, and I do think that annual vote of confidence is helpful not only for the assembly but also for the clerk or the coordinator to have that vote of confidence from the assembly.
Well said, and far be it from me to be against the status quo. But speaking of status, we're getting down to the bottom of a second hour here. So why don't we consider, there's a bunch of procedure overtures, try to steer the omnibus, treating RPR members as though they're not able to speak. Why don't we just jump ahead to another Calvary Presbytery proposal, creating a study committee on woke critical race theory. Seeing as Dr. Pipa accused my alma mater of being woke for 2 years. I heard the Polity Matters podcast kind of describe this as passé, and there's really no concern about woke critical race theory, the Frankfurt School. So maybe this is 5 years too late, but people still accuse the PCA of being woke. My perspective is I think it'd be helpful to have our General Assembly weigh in on the Frankfurt School. What do y'all think?
Well, the problem with the study committee is the General Assembly never weighs in on anything. I'm serious. As long as we have this rule that, it has no teeth, unless it's done like the federal vision, which was to investigate federal vision, in my presbytery, I helped get this through simply because I thought the people behind it should be heard. But even when I said I'm not sure I'd vote for it at the assembly. I'm just tired of study committees. And, there's been 2 or 3 that's done us some good to the point now, but they're ignored. So, for example, the study committee on Roman Catholic baptism, which said that we ought not to recognize it, but leave it to each session. And we had one of our graduates that they almost made him take an exception of a second degree to the standards because he didn't approve of Roman Catholic baptism. So study reports just don't do a lot of good. And I don't know. They all can convince me otherwise, but.
Yeah, I'd agree, just on the grounds that there has been enough time, and there are many more resources on this now out there than there were, 3 to 5 years ago. And I think this would be not the most prudent use of our resources at this point in time. So I'm not in favor of moving this one forward.
If the PCA is accused of being woke, I'm sure that a report that the PCA produces saying that we're not woke will convince many skeptics and detractors. So
I'm sure Moscow will withdraw all of its podcasts. Tim, what were you going to say?
I would love for the PCA to look into this for 2 reasons. One, I think that critical theory, critical race theory, intersectionality, and all the stuff associated with it is tearing the church apart. Number 2, it was very quick to recognize what I believe is the response to this with the quote unquote white nationalism and kinism. But I believe that started because this was allowed to fester in the church for so long. I think this needs to be addressed. It is rampant from my perspective. the language that some of our members use in whether it be on social media or in their support for different things. This is taking a hold and it needs to be rooted out.
And I will say Tim made a powerful speech at our presbytery in favor of this overture.
Well, I hope you'll bring that to General Assembly, that speech.
I do think he's right. The fact that we delayed so long is why we now have the radicals on the other side overreacting.
Mm-hmm.
Yeah. Well, any other overtures you'd like to discuss before we wrap up?
I want to go on the record really briefly with the Overture 53 on RPR members. I served on RPR for 5 or 6 years, and it's it desires to limit RPR members from speaking on the floor of General Assembly. I don't think that's the best course of action here. I'm okay if we limit RPR members from making amendments to the RPR report. They've had the opportunity to do that before, and if they have a substitute, bring a minority report. So I don't like RPR members cannibalizing the RPR report, but the report is so large that the chairman cannot respond to every query on every issue and defend every position of the committee. I think RPR members need to be able to stand up on the floor and defend, at the very least, defend the committee's position. And so even the chairman can't have a list of everybody who he should designate to speak on his behalf. That's very cumbersome, and I would rather RPR members to stand up on the floor and defend the report, as I've done once or twice over the last couple of years. I just think that's important because of how huge that report is. So I'm not in favor of this. I would rather nothing pass, but if anything is going to pass, let's stop our RPR members cannibalizing the report by making amendments to it, and let them speak in favor of it, though, at GA.
Or against it.
Maybe. I mean, that's fine. That's fine. I would rather them, again, if you're against it, file a minority report. That's your opportunity.
Okay, I see what you mean. Yeah.
But you can speak for it. If the chairman doesn't have the information readily at the top of his mind, you may have it and can speak and help the assembly with that information and that argument.
I do wonder, though.
I'll say I do think Jason's onto something in terms of minority reports coming via RPR to the floor of the General Assembly, because I think we would see more clearly the context in which some of those discussions took place in RPR. If there's simply a speech against something in the RPR report on the floor, that we don't get to see that exchange in the context, then that's more difficult for the General Assembly to vote on. And I also think it's important to consider that there's a big difference between RPR and Overtures Committee, which is that the things that Overtures votes on are publicly reported already, whereas the things that RPR votes on is for their eyes only. And so the General Assembly does not have an opportunity to see all of the presbytery records before casting a vote. And so we do rely on the wisdom and guidance and input of the members of RPR to cast those votes.
Mm-hmm.
I agree. And as far as, in my opinion, this is still the most important thing we do at General Assembly. It has saved us many, many years, many times in many years. And that's why the progressives want to keep denuding it. It's necessary they be able to speak.
Yes. And I wonder, is this overture, and obviously this goes to, is this reactionary against one dear brother from New River Presbytery last year? I
don't actually think it is. I don't think, because he wasn't a member of RPR. I think
this. He wasn't.
No, he was not.
Well, it's definitely not. That's why you shouldn't impute motives.
Right, and I think it's actually members of RPR who are upset that other members of RPR had debated it thoroughly and fully at RPR, and then they go on the floor, and in 2 minutes, nobody knew it was coming. In 2 minutes, the work of RPR was just overturned.
Right.
Nobody was prepared to argue against it. I think that's really the concern here.
Well, that's important context. I appreciate that. So people should recognize, unlike I failed to do, that this isn't reactionary. It's actually addressing a serious concern. All right. Well, anything else that you'd like to talk about? And again, there's no immunity here.
Yeah, if I could speak briefly to Overture 49, also from Northwest Georgia Presbytery, which seeks to increase
the Mo Money for AC overture.
Well, I think that's part of it. As this overture went public, most of the discussion, I think, immediately went to what participation at the General Assembly level would look like. And I think what was overlooked was participation at the Presbytery level as well. I haven't seen any discussion about how this would, I think, in my opinion, promote a lot more healthful involvement and discussion at the Presbytery level. So perhaps it is true that this wouldn't necessarily increase participation at the General Assembly level, but I think it would go a long ways to increase participation at the Presbytery level. I think our session in particular has been in a case a lot of the times where we would love to send 3 ruling elders. That 3 ruling elders are available and have interest in going and debating some of the issues, and we're only allowed to commission 2 because we're still a small church. So I think that's something to consider as well. I would also point out the Overtures library app that the Polity Matters guys put together did a nice job collating all of the advice that different teaching elders and ruling elders have given. And I want to point out for people that are using that some of the advice seems to be contradictory as well. So teaching elder Ratliff, for example, argued against this overture, saying that it would not increase ruling elder participation. We currently have scholarships and things like that that are available that are not being availed of. And so why would we believe that this would actually increase ruling elder participation? Ruling elder Donahoe said that it would greatly increase the disproportionality. Well, one of those two things can't both happen at the same time, right? Either teaching elder Ratliff is right that it would not be effective in increasing ruling elder participation, or ruling elder Donahoe is right that it would actually be too effective at increasing this disproportionality. So something to consider as people look through that advice when they're considering how to vote on this issue.
Yeah, I think you're right about Presbytery as well. But, at General Assembly, you would have to get a lot more than an extra ruling elder from the churches that send people ever to make up for the disproportionality of teaching elders over against ruling elders. That's a joke. I like 39. At least it's a move in the right direction about assistant pastors, which is unbiblical, but at least they can't be kept on a salary position forever.
Yeah. And we did an episode with the authors of those 2 overtures coming up from Florida, trying to reform the way assistant pastors are done. One, give it a sunset, and the other, give the position of the man a sunset, at least some hope that he won't be an assistant pastor forever.
Right.
Well, I do thank you all for your time and your opinions.
Right. Can we just speak briefly on one more?
Sure.
Yeah, but Overture 6.
Overture 6.
Yeah, you listened to it.
Ties into what we were discussing earlier about the 2/3 vote for coordinators. I think it's a little similar in that regard, in that the right to divide the question is the right that every member of the assembly holds. And so this overture would permanently restrict the rights of all the members of the court. I think the right to divide the question is an important one. I can think of at least 2 reasons that any member at any point might really want to do this. One might be because they simply want to understand better what's going on. It might be too much to vote on 10, 15, 20 overtures at the same time, and being able to pull things out so that they can consider each thing more discreetly and more clearly could be helpful to their right, again, in casting a vote on the floor. But then secondly, the effect of one vote might change the way in which a person votes on a different item that's also in that on gross motion. So I do think that the right to divide the question is an important one. I also think that there's a potential problem with this, in that if we raise the threshold to 150 commissioners, then a single commissioner must somehow convince 149 others to join him without being able to speak to that issue. And I think if we're going to be able to speak on it and have to vote on it, then we might as well just allow people to divide the question anyways.
Yeah, I did ask the maker of this motion, the head of the Irish Air Force, and he said that it would not be a motion, so you wouldn't be able to speak to why you want it out of. So you already have to circularize the court,
right?
In order to, which is not bad, but that's just what you'd have to do if you
and
want to.
Even though it's not being debated, every vote you're simply slowing things down another 5 minutes.
That's right.
But the main point is it's the right of any member.
Mm-hmm.
Then he has an opportunity then he can sway the court if he can make a speech against what he wanted pulled out.
Right.
and you know, I think that this is trying to solve, and this is maybe going to motives. We had a number of guys who pulled things out of omnibus that were recommended be answered in the negative by the Overtures Committee, and so the only thing that did was give them an opportunity to make a speech that it should be, what was it, recommitted to this year's or next year's Overtures Committee, which of course failed. So either way, it was not going to be approved by this year's assembly. So I don't know if the brothers didn't understand that, or they just wanted to make a speech. But maybe there's a way, and I don't want to make Overtures a commission, but to prevent the multiplication of speeches that will have no real impact on what the assembly does that year.
Or somebody could just stand up and call the question if it looks like nobody really is interested in debating it. I don't know if anybody's tried that tactic before.
Well, you know what they say about people who call the question.
On Overture 6, Ryan, I kind of had a question for our constitutional scholar, Jason. Under 39-2, with respect to RPR, so when the Presbytery records are coming to the floor of the Assembly, 39-2 says, when the proceedings of a lower court or before a higher court, the members of the lower court shall not lose the right to sit, deliberate, and vote in the higher court, except in case of appeal or complaint. And so I wondered whether this, if you could simply take it out by omnibus without any opportunity to deliberate. Let's say it's out of the RPR report, you know, there's hundreds of recommendations, and you are sitting in a presbytery and you're a member and you want to take it out, isn't the right to deliberate being removed by virtue of the maneuver? And it's unconstitutional.
Right. Yeah. And that, is it a conflict, or is it creating an exception to the general rule in that case? And I would probably say it's more likely creating an exception to the general rule for how we procedurally want to do that. But it's, you know, that is a BCO. That's the BCO, right? And the RAO is saying we're not going to honor that reality, right? Yeah, I could see that. Yeah, that's a really
take away what the BCO gives.
Right. That's right. No, that's interesting. I had not thought of that argument here. I have to think through it. There's more teeth to that than I originally thought. Yeah, that's good.
I'm very reluctant to restrict the rights of the minority, but we do need to move along as an assembly. So I think something needs to be done. I don't know if this is the fix, but I'm thankful for Ruling Elder Howie Donahoe's attempt at it. All right. Any other overtures that you want to? I know we had a bunch more on the list. I think we've hit the high points, but there's a lot to talk about. So anything else that you'd like to talk about before we say good afternoon?
Ryan, you go ahead and call the question.
All right. Well, Ruling Elder Jim Eggert, Ruling Elder Matt Lee, Ruling Elder Tim Rice, Teaching Elder Jason Piland, and Teaching Elder Joseph Pipa. Thank you so much for your time today. I look forward to seeing, I hope, all of you in Louisville in just a couple of weeks.
That's right.
Likewise.
Look forward to it.
Thanks, Ryan.
Lord willing.
All right. Thank you all.
Thank you. Thanks for hosting it.
Thanks for joining the conversation on the Westminster Standard, which is the podcast of Jude 3. For more information or to support our work at promoting confessional renewal within the Presbyterian Church in America, please visit our website, jude3pca.org. Join us again next time. I'll talk to you then.